Hi, my name is Stephanie Rollins, and this is my Business Law 1 case analysis on the case of the Beastie Boys versus Monster Beverage Company. Let's start by talking about Monster Beverage and how they got their start. So originally, they were a juice company in 1935, which was Hanson's Naturals, which is started, or Hanson's was run by Hubert Hanson and his three sons. In 2012, when the energy beverage started to outsell their juice company, they decided to rename the company as Monster Beverage Corp. Monster Energy, their company is very well known for athletics and gaming and concerts. Monster has done this by sponsoring events and by throwing parties. Monster's website claims that their energy drinks can help you be your best and be at the top of your game. For the 2022 year end, Monster had a net worth of $27 billion. So they're doing really, really well. And the Beastie Boys, they got their start with three members, Mike D, MCA, and Ad Rock. All were from middle-class Jewish families in New York. They burst onto the scenes in the mid-'80s as teenagers, rapping about the new style, which was a blend of rock and rap. In the early 90s, they mixed their sound again and created a punk rap jazz fusion, which gave them more record hits. In 2011, they released their last album, Hot Sauce Committee Part 2, which was positively received. In 2012, Adam Yauch, the aka MCA, lost his fight against cancer. And then this case all takes part right around that same time. So the case details. In early 2011, DJ Z-Trip entered into an agreement with the Beastie Boys to create a remix of some of their top songs to promote their then upcoming album, Hot Sauce Committee Part 2. And Z-Trip was authorized to offer the remix as a free promotional item. However, Z-Trip did not have the rights to sell or license the remix or authorize any third parties to use it. May 5th, 2012, Monster brought in several DJs to play at their annual event, Ruckus in the Rockies, and Z-Trip was one of those DJs. Coincidentally, the Beastie Boys band member, MCA, died the day before the event. And Z-Trip played the Beastie Boys Mega Mix, which he was authorized to do, at the Ruckus in the Rockies event in tribute to the group. Monster recorded the event and used snippets from different DJ sets, including Z-Trip's set, and put those snips into a promotional video. However, Monster never contacted the Beastie Boys to be able to use their songs in their promotional video. The Beastie Boys then sued Monster for their music, or for using their music in the promotional video, in which the jury sided with the Beastie Boys, and Monster had to pay $1.7 million for damages and for copyright infringement. My opinion, I agree with the court's decision and with the jury's decision, because copyright contracts must be in writing and it has to be signed by the owner of those rights. Monster tried to state that DJ Z-Trip had given them verbal consent at the after party, which he doesn't remember even having the conversation, and then written consent in an email. The email was a copy of the 4-minute long promotional video, which contained some of Z-Trip's set and of the Beastie Boys music, where Z-Trip replied, "Dope," to the email. To me, this does not give them the rights or the consent to be able to use the Beastie Boys music in any way. It does not follow the copyright laws that are set in place. And so with the lack of consent from the Beastie Boys for Monster to use their music in their promotional video, I find them guilty. They didn't do it. And that is it for my case analysis, and hope you enjoyed. Thanks.